Hello and welcome to the analysis of the Hindu newspaper dated January 3rd, 2023. In this video, we are going to talk about two important newspaper articles. These articles are going to be very important, very significant for the civil services examination. So do watch this video till the end, and let's now start with the first important newspaper article for the day. Now, this particular newspaper article talks about what is known as demonetization, right? So there was a judgment which has been passed regarding the demonetization. We are going to discuss it. And why is it important? It is important for the Indian economy and issues related to planning, mobilization of resources, growth, development, and employment. Now, this particular judgment was a 4 ratio judgment. We are going to talk about it. But before that, we need to understand that in 2016, there was a notification, or there was a gazette notification on November 8th, 2016, which basically demonetized rupees 500 and 1000 bank notes. Now, 500 and 1000 notes, which were present at that from that point of time, were now illegal tender, and they could be exchanged with the banks, but they became illegal from then now. And 52 days period was given in order to exchange those notes. Now, in this context, there was a judgment, there was a petition which was filed. Now, the petition was filed by the senior advocate P. Chidambaram, and he had contended that the decision making process was rushed and fatally flawed. He said that it was rushed in such a manner that the whole economy of India came to a stall. This was his points. And besides him, there were other petitioners as well. But most important was the advocate P. Chidambaram. Now we will talk about the majority judgment, which is given by the 4 judges. Then we are going to talk about the minority judgment, which has been given by our female justice Nagaratna, right? So now, what is section 26 clause 2 of RBI Act? Because this is important, this particular section becomes very important because the whole judgment revolves around the section 26 clause 2. Now, this clause 2 says that on recommendation of the central board, the central government may by notification in the Gazette of India declare that with effect from such date as may be specified in the notification, any series of banknotes of any denomination shall cease to be a legal tender. So, central board is going to recommend to the central government, and the central government is basically going to issue a gazette notification, and then that particular banknote is going to cease to be a legal tender, right? This is section 26 clause 2 of RBI Act. Now let's talk about the majority judgment, then we will talk about the minority judgment. So the majority judgment, which was led by Justice B.R. Gavai, says that statutory procedure under section 26(2) was not violated merely because the center had taken the initiative to advise the central board to consider recommending demonetization, because section 26 clause 2 talks about the fact that central board will recommend to the central government. Now, in this particular case of demonetization in 2016, what happened is that central government recommended it to the central board, and then central board further recommended it to the central government, right? This is how it happened, but this process was not followed. Now, this process, if it was not followed, it does not violate section 26 clause 2 of the RBI Act, says the majority judgment. Now, it also says that RBI and center had been in consultation with each other for 6 months prior to November 8th notification issued under the section 26(2) of the RBI Act. And on the hastiness, the majority judgment says that such measures undisputedly are required to be taken with utmost confidentiality and speed, because if you tell to the public or if the news is leaked out, then what will happen? All the money which is black in nature is going to be replaced by white money. These are the consequences of it, and that is why such hastiness can be said to be good in this particular case, right? So this is the majority judgment, and apart from it, demonetization was done for proper purposes of eliminating fake currency, black money and terror financing. And he also said that there was a reasonable nexus between the measures of demonetization and its objectives, because objectives were very clear. Objective was to destroy all the fake currency, to bring down the black money and to bring down the terror financing. And we can say that from the reports that terror financing has come down, black money at that particular point of time had come down, and at the same time fake currency also had come down. This was the basic objective and it was fully successful, right? And the central government is the best judge since it has all inputs with regard to the fake currency, black money, terror financing and drug trafficking. And as such, what measure is required to be taken to curb the menaces would be best left to the discretion of the government in consultation with the RBI. It is not the work of the Supreme Court to decide whether this particular exercise was successful or not. It should be left to the government. This is called the separation of the powers, right? So this is the majority judgment. Now majority judgment is very important. It is very important, but minority judgment can also be taken into account. Now minority judgment says that Justice Nagaratna differed, and she said that only if under section 26(2), only if the central board of the RBI had initiated the proposal to demonetize a specified series of banknotes by way of recommendation, this particular notification in itself is invalid, because in this case the center had recommended to the central board regarding this particular demonetization. But it should happen like that central board of the RBI should recommend to the government, and this particular process was not followed, and hence the demonetization process in itself is flawed. And apart from it, here in 2016 the government had initiated the demonetization process, not the central board. This is very clear to us, right? Now the Justice Nagaratna further concluded that there was no meaningful application of the mind by the central board to the government's initiative for withdrawing 500 and 1000 rupees, which formed 86% of the currency in circulation. Now 86% of the currency in circulation was deemed to be deemed to cease, or it ceased to be a legal tender, right? Now this caused a lot of financial crunch and at the same time socio-economic despair, and hence the government's decision to ban the 500 rupees and 1000 rupees notes was invalid, right? And apart from it, she said that the central board had hardly 24 hours to consider the proposal of the center to demonetize the notes, which is a very hasty process. The objectives, however, she said, were noble and well intentions, but the process undertaken was bad in the law, she's added. And nothing, however, can be done to restore the situation to the status quo ante, but the judgment could act prospectively, right? And apart from it, the official records show the central board acted merely on the assurances given by the government that embarking on the process of demonetization would result in reducing banknotes in the economy and switch over to the digitalization of the economy. This is basically the only insurance given to it, that it will lead to more digitalization and it will also lead to reduction in the black economy. This was the basic argument which was presented by the government in order, or when it recommended to the central board that the bank notes of rupees 500 and 1000 should cease to act as legal tender. So now this is the minority judgment which was given by Justice Nagaratna, right? And we have talked about the majority judgment as well. We have talked about the section 26(2) of the RBI Act. We have also talked about the petition, what was there in the petition, and how now it has been solved, right? So this is it regarding this particular newspaper article. Let's now head to the next important newspaper article. Now this particular newspaper article talks about online gaming industry, and it also says that a self-regulatory body is going to be set up according to the new draft rules. We are going to talk about the draft rules, and we are also going to talk about the online gaming industry in India, right? And these kinds of articles are important for the GS paper 2, that is effect of policies and politics of developed and developing countries on India's interest and Indian diaspora, right? So let's first understand the context of this particular newspaper article. Now this particular newspaper article says that Electronics and Information Technology Ministry on Monday proposed an amendment to bring online gaming within the ambit of Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021. Right? Now earlier we have seen on December 26 that a notification was issued where Ministry of Electronics and Information Technology ministry was made responsible for the online gaming industry, right? Now these particular amendments, or these particular amendments are in order to bring the online gaming industry under the ambit of the information technology rules, right? Now the proposal released for the public consultation requires online games to be registered with a self-regulatory body approved by the ministry. A self-regulatory body is going to be made and the online gaming industry is going to come under its ambit. And this model is similar to the rules in place for the digital news sites and the streaming services under the IT rules. Now, what are the draft amendments? Draft amendments has proposed a self-regulatory mechanism. We have already talked about it. And as of now, the age gating in 18 years, and we would like to, and the ministry says that we would like to keep it that way and see if the present framework works to expand the innovation ecosystem around online gaming while keeping it safe and trusted for the gamers, right? And how this particular thing is going to happen? This is going to happen in such a way that women account for 40 to 45% of the gamers in India, and their safety is of utmost importance, right? And that is why this particular this particular self-regulatory body will look into the women's safety as well. And he also said that our Methi minister also says that the draft rules have strict provisions against betting and wagering, and the online games that allow wagering on the outcome are effectively a no-go area. Now, the online gaming industry is very complicated, right? And that is why we need to understand this particular industry. Now, let's understand the extent of the online gaming industry in India. So according to the All India Gaming Federation, it is basically a very big economy. Online gaming industry is a very big economy. Now India's online gaming industry is expected to be worth 15,500 crores by 2023. And a 2019 survey by the US-based Limelight Works found that India had the second largest number of gamers after the South Korea. Now that is why the online gaming industry must be regulated, and it is now going to be regulated under the IIT rules, right? And India, while time spent online is not as high as in the other countries, the survey found that almost a quarter of adult Indian gamers had missed work while playing games. This is the basic criticism of the online gaming, right? Because in while playing the games, people forget about the time and they do miss at the workplaces as well, right? Now let's talk about the types of the online gaming. So the first kind of the games, there are 4 types of games, right? First is the esports, which is basically well organized electronic sport which include professional players. Now this is a totally different field. Now professional players are involved and all the people are very professional, and there are many leagues also they are that are played, and the players or the professional players are paid a lot of money. Now the second kind of online gaming is the fantasy sports, which chooses a real life sport like football, and the players win points based on the players performance. And the third type of game is the skill based game, that is mental skills are deployed into it. And the fourth kind is chance based on activity like roll of a dice. People do play Ludo in the online field, right? Now this is a chance based game. Now chance based games also include what is known as betting, but according to the METI or Ministry of Electronics and Information Technology, these kinds of games are a strict no, right? So now these are the 4 types of games. Let's now talk about the debate regarding the game of skill versus the game of chance in online gaming, because that's important, because a skill game is important, but at the same time chance games are not that important. They do not bring any kind of skill, and that is why they are not that important, right? So various high courts have legitimized gaming formats like the fantasy sports etc and as online games of skill, and rulings like Varun Gumbar versus Chandigarh, Gurdeep Singh Shashar versus Union of India, Avinash Mehrotra versus Rajasthan have found fantasy sports of a predominant format to be the games of skill. And in the Jungly Games case, the Madras High Court ruled that games like poker and rummy are games of skills, right? So this is the basic debate surrounding it. Let's now talk about why India needs to regulate online gaming, or it is going to regulate it, right? But the first, and there are threefold reasons of why the regulation of the games is so important. Now the first one is the gaming addiction, because children get addicted to the games, and at the same time adult gamers are also getting addicted to the games, and they are missing out on the working hours and the regulation of the online games, and that is why it becomes important. And apart from it, you are just sitting around in the computers and playing your games, or you are sitting around in your mobile phone. This will impact your health in the long run. You are going to be more unhealthy, and that is why the impact on the health is very vast when you are just playing the online games. And apart from it, there is also a concern of the women's safety. Women are sometimes extorted or sexually abused in the online games, and that is why there is a concern of the women's safety. I mean, apart from it, there are various concerns regarding it, but we will just boil down to three important reasons of why regulation of the online games should happen. First one is gaming addiction, second impact on health, and the third one is the concern of women's safety. So this is it regarding this particular newspaper article, and this is it for the day. Thank you from my side. Do like and share the video and subscribe to this channel. Have a good day. Bye.